that this withdrawal of prosecution in this matter have been done to give benefit to the accused police officer. Sufficiency of the evidence is there. Then withdrawal of the prosecution was also wrong. And what is the public policy? Will be filled up here to save a police officer. Is it a public policy? Constitutional morality that's an obligation on the every person is inquiring into the matter. Let's go. Let's take it fast. In this review, I have made my earlier argument. Effectively, your lordship is inquiring into the matter that whether any injustice has been made in a short campus. When the deceased wife has come, there are so many factors, so many incidents have happened. And it's a case, rarest to the rare case. And your lordship is considering that whether there is an injustice by the state police. This is the crux of the matter. Now, my lord, I will submit that this withdrawal of prosecution in this matter have been done to give benefit to the accused police officer. These points, whether withdrawal of the prosecution would have been challenged at earlier stage or not stage, my lord, in this matter, these are irrelevant factors. Ultimately, what your lordship looks into the matter, that is the inquiry. Whether despite the findings, police could have given a FRT or not. When there is an evidence, whether the police could have given the FRT or not. If this is the situation, whether withdrawal of the prosecution was right or wrong, that your lordship also can look into this matter.
Because I don't find any public policy involved in withdrawal of the prosecution.
No, I'm just giving the lordship the judgment. Whether the background of the case, your lordship is now well over 1, 2, 3, 4 minutes. I have made a very short written arguments. Now, in such a scenario, whether the police authorities were right to withdraw the prosecution or not, what are the principles of law involved? Now, first I will cite to your lordship 1987 1 SCC page 288. This is a 5 judges bench judgment. Theonandan Paswan versus State of Bihar and others. Kindly come to paragraph 19.
1990.
Section 321 CRPC is virtually a step by way of composition of the offence by the state. This lordship, my lord, has got it, my lord?
This one.
Paragraph 90.
Yes.
Section 321 CRPC is virtually step by way of a composition of the offence by the state. The state is the master of the litigation in criminal cases. It is useful to remember that by the exercise of function under section 321, the accountability of the concerned person or persons does not disappear. A private complaint can still be filed if a party is agreed by the withdrawal of the prosecution, but running of the possible risk of a suit of malicious prosecution if the complaint is bereft of any basis. Since section 321 does not give any guideline regarding the grounds on which a withdrawal application can be made, such guidelines have to be ascertained with reference to decide cases under this section as well as its predecessor under section 494. I do not propose to consider all the authorities cited before me for the reason that the court had occasion to consider the question in all its aspects in some of its decisions. Suffice it to say that in the judgments rendered by various high courts, public policy, interest of the administration, inexpediency to proceed with the prosecution for reasons of state and paucity of evidence were considered good grounds for withdrawal. In many cases are not good grounds for withdrawal. In certain other cases, depending upon peculiar facts and circumstances of the case in those decisions. Can you pause for a moment here? If your lordships accepts our submission, then in that case, the trial has to be start. On what basis your lordships will pass the order? Point is only whether on records, is there any paucity of evidence or evidence is there? That is the opening of the new pathways to decide the case. Whole case is rested on this, my lord, today. Whole case is rested whether the evidence were there. If the evidence were there, then the writ court will exercise the power. If these evidences, whether the FRT which was filed was rightly accepted by the magistrate, was it proper? Suppose someone who made the earlier the complaint was lodged by the person who, on the basis of which the proceeding had been started, he has withdrawn himself for whatever the reasons. Does it mean that the evidences which were collected and which are on record, that will be wiped out? Therefore, if there is sufficiency of the evidence is there, then withdrawal of the prosecution was also wrong. And what is the public policy? Will be filled up here to save a police officer. Is it a public policy? It cannot be a public policy. My lord, nowadays we speak about constitutional morality. Constitutional morality, that's an obligation on the every person. I mean, those who are in the state and etc., etc., etc. Leave aside constitution, morality. What is a morality? What is a fairness? In a given case, a normal man, leave aside prudent man. I am not talking about prudent man. That's how he goes, how he thinks. My lord, kindly just consider, I am talking about this. When you transfer the investigation from one agency to another agency or another CBI agency, what do you write? What the court writes? To instill public confidence. What is essential in the matter of criminal matter? In a criminal case, court has a duty to instill confidence amongst the people at large, amongst the society. Therefore, there is a whole action, including the part of the court, judicial court, there was a breach of constitutional morality. The withdrawal of the prosecution is not a factor at all. Your lordships can set aside even. Although directly it has not been challenged. In a writ court can mold the relief even. And writ court, when considering a question, my lord, I was thinking about that, and I was said in very recently in one court that in this constitution, you look, I can see the constitution in two ways. This is my thinking, my opinion. One is people's right. Another is the running of the government, etc., etc., judiciary, etc., etc., etc. Of course, there is a public interest as well, but directly people's right, which is required to be kept by every authority who has been created by the second part. Now, your lordship has seen the fundamental right. In the fundamental right, there are rights, but to me, the precious right of a citizen of the country, leave aside citizen of the country, anybody who comes in India, the precious right is right under Article 21 of the Constitution. Most precious right. Most precious right under the Constitution is Article 21. Your lordships will find Article 14 has been interpreted. Classification, reclassification, so many things are there. Article 16 is based on that. You can classify. No, Article 14 is not applicable. Article 16 is not applicable. Article 19, regulated by law. But Article 21, precious right, right under Article 21, is not regulated by any law. If there is any procedural law which directly or indirectly abridges the right of that precious right, either that law has to be ignored or that law has to be set aside. Fundamentally, a court under Article 21 is a constitutional court. A constitutional court is a guardian of the citizen. But time will come, time will go. The democracy or the right of the people have been established, re-established, or it has been taken, enforced, or extended only by the Constitutional Court. There are times, we have seen that times, there's a confrontation between the government and the judiciary, whatever it may be the reason. Whether any government, whether he is right or left or saffron, they do not like the power of the judicial review, the power of the Constitutional Court. They do not want to subservient of the powers under the judicial review, powers under the Constitutional Court. They do not like it. Whoever is the government, I am not saying about it. So long he will remain in the opposition, he will say, court is the last word. The moment he will go into the power, he will say, no, I am the last one. This is our country. In this country, this is the way, my lord, judiciary has been expanded. Judicial power, judicial interpretation, judicial things have come, which we have never thought it. Rather, when the constitutional maker makes the constitution, they have never thought it, our governors, they will not work on the basis of the advice of the government, state government. Today, what is the confrontation? Confrontation with the governor and the state. A reference is going on. Lots of you have seen that. Therefore, where we have come today in the problem, question therefore remains, my lord. Very fundamentally question remains whether each and every action, whether any favor is there or anything is politicizing or not. Therefore, my lord, today what your lordship's court's power is there, this power doesn't enjoy by anybody. And this power is a very precious. This power has to be exercised. Constitution never. My lord, constitutional provisions have to interpretation, we have to make an interpretation of the Constitution in a very positive manner. Rather, it is our duty, not only the court's duty, because we are the lawyers, we assist the court. It is our duty for making advancement of the constitutional right of the citizens of this country. For whom? First, the precious right has been taken away to that person, Article. Most precious rights. Most precious right. Therefore, your lordships will examine that whether public policy demands to withdrawal of the case. Next judgment. So, the central question is whether the public prosecutor has really applied his mind to all the relevant materials on record, and satisfied himself that the withdrawal from the prosecution would subserve the cause of the public interest or not. Be it stated, it is the obligation of the public prosecutor to state what materials he has considered. It has to be set out in brief. The court, as has been held in Abdul Karim case, is required to give an informed consent. It is obligatory on the part of the court to satisfy itself that from the material, it can reasonably held that the withdrawal of the prosecution would serve the public interest. It is not within the domain of the court to weigh the materials. However, it is necessary on the part of the court to see whether the grant of consent would thwart or stifle the courts of law or cause manifest injustice. Manifest injustice, not only injustice. Manifest. A court, while giving consent under section 321 of the court, is required to exercise its judicial discretion, and judicial discretion as settled in law is not to be exercised in a mechanical manner. The court cannot give such consent on a mere asking. It is expected of the court to consider the materials on record to see that the applications have been filed in good faith, and it is in the interest of public interest and justice. Because this is very important. Another aspect of the court is obliged to see is whether such withdrawal would advance the cause of justice. That's the facts of the case. Next case, Nominal 2021-17 SCC 318, paragraph 25. The principle, the principle which emerges from the decision of this court on the withdrawal of a prosecution under section 321 CRPC can now be formulated. Section 321 ensures the decision to withdraw from a prosecution to the public prosecutor, but the consent of the court is required for withdrawal of the prosecution. The public prosecutor may withdraw from a prosecution not merely on the ground of paucity of evidence, but also to further the broad ends of public justice. The public prosecutor must formulate an independent opinion before seeking the consent of the court to withdraw from the prosecution. And your lordships will be able to look into that, whether the public prosecutors have formed any opinion or not. Individual. Now, these are the purpose. Now, another judgment I will show, and I will stop this chapter, this topic. That is our High Court judgment, Justice Subhashachi Bhattacharya. 2022 SCC online 4460. The law is clear on the subject. Paswan's case was undoubtedly a landmark judgment on the scope of section 321 CRPC and laid down the roadmap for the PP as well as the court. The principles set out in the said judgment have not only been reiterated but explained and elaborated further by the Supreme Court in several subsequent and more contemporary judgments. Judicial opinion has somewhat crystallized to lay down certain cardinal principles governing the withdrawal of prosecution under section 321 of the CRPC. Those may be summarized as follows. The withdrawal should be only in the interest of justice and subserve public interest. The VPP does not act as a mere postbox or act on the dictates of the state government, but has to act objectively, as is also an officer of the court. Even if the government directs the PP to withdraw the prosecution, an application is filed to that effect, the court must consider all relevant circumstances and find out whether the withdrawal of prosecution would advance the cause of justice. This is the case. Now, my lord, when a case allegation is there that a police officer has killed the victim, how there can be withdrawal of a prosecution? How there can be withdrawal of the prosecution? Well, this is the one part I will finish. Now, my lord, next second part is that the Miller victim compensation. For long years, my client is suffering. Long years, justice has not been made to him. It is almost a decade has gone, more than 15 years have gone. How she is surviving?